Amy McDonnell, Litigation Counsel at Chesapeake Bay Foundation, and I will very briefly just touch on the legal requirements. We feel that the current administration is required legally to perform this programmatic impact statement for two reasons. The first is under NEPA, the National Environmental Policy Act. NEPA was basically the first environmental law, and it requires that before federal agencies, and it includes all federal agencies, make any decision that they must consider the effects of their actions on the quality of the human environment. And there's many ways to do that, but most importantly here is through the environmental impact statement. And that environmental impact statement will look at all of the major federal actions. It will look at indirect, direct, as well as cumulative impacts and determine what the next step should be. And based on that analysis, CEQ, along with the agencies, would then need to promulgate any necessary regulations that would be required under that analysis. Here, this is a perfect example of why a programmatic environmental impact statement should be done, because we have multiple agencies that have some authority over different aspects of drilling. And so in order to make sure that the cracks are filled, we need to have a cumulative impact study done to see where the cracks are and how we address those issues. The second issue is under the Chesapeake Bay Executive Order that was signed by President Obama back in 2009. And under that executive order, there's a requirement to not only improve the water quality of the bay, but also to conserve landscapes and ecosystems. And so under that executive order, we feel that this study needs to be completed so that the administration and all the federal agencies can best determine how to meet those goals. Ultimately, this is an unregulated source of pollution. It does not square with the Chesapeake Bay Executive Order or NEPA, and therefore this administration must stand by their commitment to the bay.